Good morning, counsel.
Good morning, Your Honors. May it please the Court, Thomas Kenny on behalf of the appellant Judge Billings. In my view, Your Honors, if the Court affirms the Superior Court decision, it will have, in that decision, decided, that judgment decided that the offense of malicious prosecution occurs for insurance coverage purposes upon the filing of the malicious action.
Upon the bringing of the malicious prosecution.
No, Your Honor, on the filing of the underlying malicious action.
But that is the alleged malicious prosecution.
Yes, Your Honor.
I'm sorry. Why isn't that logical? That's the offense, so to speak. It's the filing of an abusive prosecution.
Well, Your Honor, one reason I would suggest it's not logical is because the insurance policy covers the insured party. It doesn't cover the alleged victim of that prosecution. And the insured party's jeopardy does not arise until the malicious prosecution is a mature cause of action. And in Massachusetts, that does not occur until the prosecution is terminated in favor of its defendants.
Why isn't it a mature cause of action? Isn't it a mature cause of action when it's brought, not when it's ended?
No, Your Honor. In Massachusetts, my understanding is that an essential element of the tort is termination in favor of the defendant.
Okay, yes, it's an essential element of the tort.
But if the policy is talking about offense, why isn't the offense the actual bringing of the action that somebody later is going to say was malicious prosecution?
Well, I would suggest, Your Honor, that has to do with the interpretation of offense. The policy interprets an offense as malicious prosecution.
Right.
But the malicious prosecution does not occur until it matures into a cause of action.
Well, it's not discovered. Why isn't this sort of like the discovery rule in Massachusetts? We don't discover, we don't know that somebody has committed the tort of bringing the wrongful action itself until such time as a court says it was wrongful. But it was when it was filed.
Well, the filing certainly is is one of the essential elements, Your Honor.
Well,
but it is not the tort does not mature into an actual cause of action. In other words, the suit cannot be brought until that is terminated.
But if you're looking at the word offense, and then you're also just thinking about what makes it an offense. What makes it an offense is the things that it's causing the person who's ultimately going to bring the malicious prosecution action to experience, right? That you've got this.
Well, I would think, Your Honor, that is confusing offense with the harm that is brought.
Well, that's what you're seeking the insurance for, right? To pay for that harm, aren't you?
You're seeking insurance to protect your assets, Your Honor, from the malicious prosecution action that will be brought against you. Right. I would like to point out that the American Insurance Association amicus brief clearly states on page 4 that it is the offense that triggers the insurance coverage, not the harm that comes from the offense. And that offense does not come into being until there is a termination of the policy.
You say that Judge Quinlan was in error in relying on the Royal Indemnity case, and I think that your primary reason is because you say that in this way the insurance company could be lulled into giving insurance, extending coverage so that the plaintiffs here, for instance, the people who were responsible for the malicious prosecution, until the plaintiffs would perceive the impending problem from a suit in which they were already involved. But why isn't that problem easily solved by a question in the application for insurance? Are you under, or do you believe that you're going to be a defendant in a malicious prosecution suit? And then if the person, the insured, doesn't answer that honestly, then the insurance company will not have to defend.
I completely agree with you, Your Honor. And that's the position of Billings. And it's the position of the dissent in the Royal Indemnity case that they can ask whatever questions they want. In one of the questions they can ask the insurance applicant is, are you involved in any pending litigation? If they don't ask that question, it apparently is not material to their underwriting decision. If they do ask it, and if the answer is yes, then the insurance company can do whatever investigation it feels is appropriate regarding that lawsuit and make an underwriting decision as to whether or not to issue that policy. If the answer is no, and if the answer is misleading, then the insurance company is protected by Chapter 175, Section 186. So I would agree with Your Honor that the concept that you should not have the offense or the cause of action take place upon termination because an insurance company may be lulled into providing insurance doesn't really make an awful lot of sense. It protects the insurance company from its own laxity in failing to ask the question about pending litigation, but it doesn't make sense from a logical point of view because it does nothing but protect the insurance company.
Mr. Kenny,
I'm sorry. Under your reasoning, I assume that defamation does not mature until there is a damage to reputation, correct? Isn't that an element of the tort of slander or libel?
It is an element, well, I don't know that, it is an element of the tort of slander, yes, Your Honor.
Okay, so under your reasoning then, the time with regard to a defamation would only be when the reputation is damaged, not when the defamation is spoken. By your reasoning.
I would agree with that, Your Honor, but I would think that it would be simultaneous. I mean, it's a situation where once the slanderous comment is made, there's an inference that could be drawn that the reputation has been damaged.
You're assuming it's published and immediately disseminated and known to others. If it takes time, you're saying that it focuses on so in your view, it's not when you speak of the defamatory words, it's when the damage to reputation occurs that the action then is, that's the time with regard to the insurance coverage.
I think my view would be when you speak the words, Your Honor, because I think the inference that would be drawn is that once those words are spoken, you don't know when they're going to be disseminated, and there's probably no way to literally pin down the moment that the reputation is damaged. So I think that tort would come to fruition and would mature upon the speaking of the defamatory word and the publication thereof.
Because for malicious prosecution, you suffer the damage as soon as you have to retain an attorney to defend it. I mean, malicious prosecution, as soon as you retain an attorney to defend a malicious suit, you have injury.
That would be true, Your Honor, from the victim's point of view. But as is pointed out in the case of Baylor Air Conditioning, which is cited in Billings' brief, Your Honor, the insurance, or rather the harm to the insured takes place when jeopardy attaches to the insured. And jeopardy attaches to the insured in malicious prosecution only once it is terminated in favor of its defendants. I would like to point out to the court also that if you take the view of affirming the Superior Court decision that malicious prosecution occurs upon the filing of the action, in a sense you facilitate and perhaps encourage the filing of malicious actions. Because one of the barriers to filing is the potential that the plaintiff in a malicious prosecution action will himself become a defendant in a malicious prosecution claim. And if you have the malicious prosecution occurring for insurance coverage purposes at the time the case is filed, that plaintiff can have insurance in place prior to the filing date, which he has absolute control over. And the second that he goes to the courthouse and files his malicious action, he is insured for any defense or indemnification or any judgment that might come against him for that malicious prosecution. So in effect, that takes away the jeopardy that he has that may deter him from filing that malicious action because he has nothing to lose any longer.
Mr. Kenny, what do they do in other states? And what do they do in the federal system on this?
there's a mixed bag in other states, Your Honor. I do not know what they do in the federal system. The majority of states, my understanding is, follow the determination that the occurrence is upon the filing. However, I would suggest that the dissent in Royal Indemnity and also the Ross v. St. Paul case, which was cited in a supplemental citing by Mr. Billings, makes a lot more sense as far as deterring the filing of malicious actions, because it has it occurring upon the termination of that suit. When in all probability, there is not going to be insurance available for a person after he files his malicious action.
But what about the duty to defend? You want the defense in the malicious prosecution suit, right? If you're the insured?
Sure you do.
So then you want them to have to come in and defend you as soon as the suit is filed, not wait till there's already a judgment against you.
But there's two suits. You
Yeah.
don't have the malicious prosecution suit until the first suit was brought that becomes the basis of the malicious prosecution suit.
Right, but you're saying that the suit for malicious prosecution must be terminated.
No, I'm being misunderstood, Your Honor. Perhaps I'm not being clear, Your Honor. The suit for the malicious action,
Yeah.
which is filed, is
Here
the
the
basis of the
1998
malicious
suit,
prosecution
yeah.
that follows.
Yeah, okay, all right. That has to be terminated in favor. Okay, which it was in
That's correct.
2000. Okay.
Now, if I could turn you to your second argument, which is
Yeah.
that you're entitled to coverage based on the intentional infliction of emotional harm claim. Is it your view that that intentional infliction of emotional harm claim can stand without the malicious prosecution, that it would be sufficient to make out that claim to say that the defendant was rumor mongering about Mr. Peterson building 16 lots in wetlands? Would that be sufficient to support that claim?
I think it is sufficient. I think that the rubric, infliction of emotional distress, should not be what controls, Your Honor. I think you look at the entire complaint within the four corners of the complaint, and if you can reasonably find slander in what is set forth in that complaint, I believe the slander can stand by itself without the malicious prosecution. And I would point out to the court that what Mr. Billings is alleged, and his co-defendants are alleged to have done, is to have claimed that the Peterson brothers were going to fill the wetlands and build 16 houses in the marsh, which would be a clear violation of the Wetlands Protection Statute. And undoubtedly, the inference here is that they were doing this without the benefit of a permit of any kind. So they would have been engaged in criminal behavior because a violation of the Wetlands Protection Statute is a criminal act. And under Foley and the Draghetti case, I believe, the violation of the allegation of criminal behavior is slander per se. You don't need anything beyond that. The inference in the allegation of criminal behavior is that the reputation has been damaged.
As between insurance companies, that is, an insurer who who had a policy that was issued on the date of the activity that we're talking about,
The filing,
versus the insurer who issued the policy during the period in which the judgment came back that there was no merit to the claim. As between those insurers, who is it most fair to have bear the burden of coverage?
I would say it's most fair to have the insurer who was on the hook at the time that the action was terminated, because that insurer, had it asked the insurance applicant whether or not he was involved in pending litigation, would have found out that this pending litigation existed, would have had the opportunity to investigate that case and decide whether or not it wanted to issue the policy. If it was too inept or lax to have asked that question, then I would suggest that it was not material. On the other hand, Your Honor, if the insurance carrier who was put on the hook before the action was filed and is on the hook at the time that the action is filed, they would have no opportunity to discover this case because the applicant could have answered no when asked about pending litigation, assuming he had bought the policy the day before he filed his case.
Could I ask you this question? I'm looking at the Erie case, which says under Pennsylvania law, the general rule is that a tort occurs for insurance coverage purposes when the injuries caused by the tort first become apparent or manifest themselves. So what is the rule in Massachusetts on what is the general meaning of occurs for that?
General meaning of occurs, I understand it, for personal injuries, Your Honor, is when the cause of action arises.
That's for everything? That's not?
Well,
It's not when the injuries manifest themselves?
well, it's often simultaneous. I mean, in a car accident, we have.
But if they aren't?
If they're not, it's when the cause of action arises.
All right.
Thank you, counsel.
Thank you, Your Honor.
Good morning. May it please the court, my name is John Hurley, and I represent the defendant appellee in this case, Commerce Insurance Company. I just wanted to respond to one question that Justice Ireland had raised as to what other jurisdictions do. I cited a case, the selective insurance case, that was decided in 2010. It's a federal court decision in Illinois. I didn't cite it in my brief because it had not been decided at that time. I did it by letter. And in that case, the judge lays out pretty much all the cases that have addressed this issue of the malicious prosecution for insurance purposes. He ruled there were two cases, or found there were only two cases, both in the 1970s, one from Florida that my brother mentioned in his letter, and another one also in Illinois that was overruled on other grounds. All the other cases have found that for insurance purposes, the occurrence is when the maliciously prosecuted suit is filed.
If I could turn you to the second argument.
Yes, sure.
Why is it not the case that this intentional infliction of emotional distress claim is in effect a claim of slander, and that we can't tell from the complaint when the slander occurred, and it arguably may have occurred after March 15th, 2000?
Well, a number of reasons. First of all, for the reasons set forth by the judge below, that there was no reference to reputation to harm. These complaints, although the label is not necessarily the determinative, were complaints alleging intentional infliction of emotional distress and negligent infliction of emotional distress. The intentional count just follows right along with the language in the Aegis case, outrageous conduct beyond what you can endure in the complaint. Also, the allegations in the complaint about spreading the rumors are always tied with the filing of the lawsuit. And in fact, in count 4 of the complaint, that's an allegation by, I think it's Scott Peterson, one of the Petersons, that he had some kind of medical problem from emotional distress, followed closely on the heels of filing of the lawsuit and the spreading of the rumors. So they're always tying them together. Additionally, if you look at the facts in this case, it's pretty clear from some of the testimony of Mr. Billings and everybody that he thought this case was over in 1999, and that, in fact, he had signed the document that's in the...
Okay, but in a duty to defend, we don't look to the testimony in the underlying case. We look to the complaint, and the issue is, at the time of the complaint, should the insurance company be defending? You don't necessarily wait to see how it may play out in discovery to determine when you're going to defend. No. Why should we look to that evidence?
That wasn't discovery in the... That was a discovery in this declaratory judgment case, not in any of the prior cases. In other words, I asked Mr. Billings, I took his deposition in this case.
Right.
What was going on? And he said, well, we signed releases. Everybody signed them, but he didn't realize or wasn't told that the Petersons didn't. And as far as he was concerned, everything was over in 1999.
Okay, so you're saying that in ascertaining whether an insurance company has a duty to defend, the insurance company can say, we're going to wait until we take the deposition of the insured to see what the situation is? Don't you have to rely upon the allegations in the complaint?
Yes, Your Honor. I'm not saying we have to wait until that, but in fact, that is what came out. But if you look at the allegations of the complaint, everything is tied to the filing of this lawsuit. The underlying lawsuit filed by Mr. Billings, really all it was, and it's in the complaint, he was appealing a land use case. He was alleging, he and his neighbors, that their other neighbor was going to do something in violation of the zoning laws. The other neighbor said, I'm grandfathered. I don't have to comply with the zoning laws that you say I do. He filed a lawsuit. There's evidence in the case that that lawsuit was dismissed 15 days after the policy was purchased, and that the reason given was the failure of the parties to comply with a NISI order. So it says the case having been reported settled, presumably more than 15 days before, and it turns out there's a release in the file that Mr. Billings at least signed in 1999, and Mr. Billings testified that the project was scaled back after 1999 by the Petersons.
So is your point that therefore there could not have been any rumors spread, any slander after March 15th?
That it's a stretch. That's a stretch when you look at this complaint, which says filing of the lawsuit and spreading of rumors. It's a land use case. It's about development of some fine property in Falmouth.
You're not, though, it sounds like. I mean, the judge obviously didn't go that way. She said it doesn't raise defamation or slander.
Correct.
But
that's what she did.
But I guess on that point, two questions. One is, your own person seemed to indicate that, yes, it would. And I'm not saying because somebody who represents the insured is binding on the insured, but it does suggest that that there may be a reasonable understanding of those allegations that they would implicate defamation or slander, because why else would you, I mean, you're humiliated because your reputation has been hurt because somebody's saying that you're going to tear down the marshlands and build 16 houses. So it seems to me your own people support the view that that is a reasonable interpretation of this complaint.
Well, the adjuster who was testifying, her basis for denying the defense was the date of the occurrence.
That's right.
For both
right.
aspects.
So I'm just talking about what the judge said, which wasn't the date of the occurrence. So you think the stronger, let me ask you, is your stronger argument as to why this isn't covered because, as you say, the filing of the lawsuit on March whatever, and the rumor mongering are like that?
Correct, but I argued both below. The judge pointed out, and I think I argued that the Boston Symphony Orchestra case, which sort of opened up that language in that case, had different language in the policy. There was other disparaging material, and the court said, okay, you didn't say defamation, but you said something disparaging. Our policy has specific torts. It doesn't say other disparaging material.
And aren't there specific pleading requirements for defamation?
Yes, Your Honor.
Which weren't met here.
No, Your Honor, but what was pled was a tort that this court has recognized and created or approved for intentional infliction of emotional distress, and it has some magic words, and those magic words are used in that complaint. And then the next one count is negligent infliction, and that is said to follow closely on the heels of the filing of the lawsuit. And obviously, it seems a reasonable interpretation that the spreading of rumors and the filing of the lawsuit would have been at or about the same time, and there's nothing in the complaint that says it was at some other time. So that was my point with respect to that.
What do you say under Massachusetts law, as opposed to Pennsylvania law, occurrence? Is there a sort of general understanding of what occurrence means for purposes of these kinds of policies?
I think occurrence in this policy, there's two kinds of occurrences in this policy. There's bodily injury coverage or property damage coverage arising out of an accident. basically.
Okay, but
which-
that's not at issue.
And then they plug into the definition, occurrence also means offense, and these are offenses. In
Right.
fact, most of these are intentional torts, and this personal injury coverage is another kind of coverage that you get for certain enumerated intentional torts, and only those torts. And I would suggest that the word says offense, and offense is when you did the offending harm, and the selective insurance court, and also the Newfane case, which I've cited, which Your Honor had brought up, says offense is when you do what you did, in this case, file the lawsuit. And that, just as when you falsely imprison someone, that's when the offense is. The harm may come at that time, may come somewhat later. Just in a personal injury case, your harm may continue, your damages may continue. So that would be our position with respect to that, Your Honor. My brother pointed out the Baylor case in his brief. I just want to point out that that is not a malicious prosecution case at all. It has nothing to do with malicious prosecution. It has something to do with payments to pension funds and some failure with regard to that, and when the cause of action after that arises. And also a question was posed, I believe, as to why doesn't the insurance company just ask a question?
Right. I mean, isn't that a good policy point? I mean, from a protection point of view, the insurance company's in the driver's seat when someone applies for insurance. They can ask all kinds of questions about, do you have lawsuits pending? What was your role in those lawsuits? And can make a judgment about whether there might be some liability coming back to your insured.
First of all, the other cases in the other courts, only the dissent in Werner has raised that as a reason to say that the occurrence occurs at some other time. Secondly, this is an objective standard.
That's a pretty good reason, though, isn't it? I mean, the insurance company is in the best position to protect itself.
But by saying that the occurrence occurs when the suit is filed, there's an objective standard there. In this case, it is entirely possible, based, again, after the fact on Mr. Billings' deposition, that he would have said there aren't any pending lawsuits, because he testified he didn't think there were. He thought it was dismissed. And then we would have had a whole question of whether he made a misrepresentation or not, and we would have had to get into that. By having an objective standard that says everybody knows this is when it is, then when the filing of the lawsuit.
So you don't have a problem if Mr. Billings comes in today and buys insurance from you, knowing that next week he's going to file a lawsuit, and who knows what might come from that?
I was thinking of that question, Your Honor, and in researching this, although it wasn't part of this case, I came across the known loss doctrine. Mm-hmm. So I suppose at some point, if someone knew he was going to file this lawsuit and knew he was going to do it to, I don't know, perhaps interfere some closing or some financial benefit, and bought a policy the day before, then the insurance company may look at that particular circumstance. On the other hand, if you have one in effect and it's been covered for a long period of time, then the insurance company has you, and if you happen to file one of those lawsuits while you're covered, then you may have, if you have personal injury coverage, then you may have the opportunity to be defended by the insurer. Just in closing, Your Honor, I believe that the decision below was consistent with the vast number of cases that have been presented with this question throughout the country in state and federal courts. No recent decisions go the other way. The most recent one, the selective, goes in favor of our position. Again, with respect to counts 3 and 4, there's no specific reference to defamation, slander, or libel in the complaints. There's no reference to harm to reputation in the complaints. It is always tied, as I said before, to the allegation of filing of this lawsuit as a means to, allegedly a means to retard the development that the underlying plaintiff, Mr. Peterson, wanted to do, and it's all tied together, and I don't think you can interpret it to be anything other than that.
Is this a standard clause within the industry? Personal injury is defined as libel, slander, or defamation in malicious prosecution.
Well, what I understand is that more recently, I don't know how, maybe 10 or 20 years, 15 years, insurers have begun to offer this personal injury coverage, which is
For intentional torts.
for certain intentional torts. Wrongful eviction might be the one where it comes up the most. And so some of the cases are being worked out as time goes on, because this is a fairly recent coverage, not, within the last few years, but there's been a few cases in the appeals court and here, I believe, on some forms of personal injury coverage or coverage for slander and things of that nature.
Thank you, sir.
Thank you, Your Honor.
All right, we'll take a brief recess.
All rise.